I'm going to thank you for joining my workshop today, first of all. I'm going to start off by telling you a bit about myself, and then I will discuss my work at Innocence Canada as a staff lawyer. If you have any questions throughout the presentation, feel free to write them in the chat function. I will leave time at the end of the presentation to respond to as many of the questions as I can. So I wanted to start by telling you a bit how I came to work at the organization. I actually started in a completely unrelated field. I did my undergrad in anthropology with a specialization in archaeology. I then went on to do my master's degree in bioarchaeology, and I worked for a couple of years in archaeology before deciding I wanted to be a lawyer. This goes to show you can really come from any type of background before going to law school, and I think it makes it, it improves the legal profession because it means people with a variety of experiences and ideas and skill sets are joining as your colleagues. So I primarily wanted to get into law to help people, and criminal law is an area which I thought I could achieve this, either as a Crown or as defense counsel. People caught up in the criminal legal system have faced a great deal of trauma in their lives. Victims often deal with the negative impacts of crime for the rest of their lives, and assisting them through the process is an important part of the role of Crown Counsel. Most people who have been convicted of crimes in this country have also been victims of some kind in the past as well. So they are often from poor socioeconomic backgrounds, haven't had the opportunity to obtain a good education, and come from unstable homes. They enter a cycle of abuse, which becomes very hard to escape, and it often leads to crime, either to support themselves or as a reaction to the horrible circumstances in their lives. Now, this isn't a universal truth by any means, but it's something important we have to keep in mind as lawyers. So this is why we have to deal with everyone coming into the criminal justice system with compassion and understanding. It's really important as a criminal lawyer. And while the crime that the accused might be accused of may be horrible, we don't know their history and what they've dealt with in the past. So it's important to understand this both as a defense and Crown Counsel to come to the best resolution in that case. Finally, there are also people caught up in the system and convicted of a crime who are in fact innocent. And this is what I'm going to talk to you about today. So just switch the slide. Before I talk to you about Innocence Canada, I'm going to tell you a bit about different practice areas in criminal law. Lawyers who work in criminal law have a few different options in terms of areas of practice. Some lawyers might choose to work for the Crown, defending criminal cases on behalf of the government, and some choose to become a defense lawyer. And a defense lawyer's job is to represent their clients both in and out of court when their client is suspected of or has been arrested for an offense. Some defense lawyers work on what's called a legal aid certificate. This means that Legal Aid, which is a nonprofit organization, pays for your client's legal services because they cannot afford to pay for their own lawyer. Some clients can afford to pay for their own legal services, in which case they will hire a lawyer directly and pay that lawyer. While these are the two main areas of practice in criminal law, some lawyers also choose to specialize in different areas. This is more common in some of the bigger centers like Toronto. So some examples are working primarily in mental health court, and this deals with accused who have mental health issues. And the court is specialized to deal with their needs throughout the process. Another example of a specialized court is Gladue Court. Gladue Court is for accused who self-identify as First Nations, Métis, or Inuit. They integrate Indigenous cultural practices and use Gladue principles to inform sentencing. This means that they take into account the individual's Indigenous background and the impact and history of discrimination against Indigenous peoples in Canada when coming up with an appropriate sentence. A lawyer may also do mainly appeal work. This means they would represent their client after their client has been convicted of a crime. Their client has the option of appealing a conviction and or sentence, and they can appeal first to the Court of Appeal for their province. If the Crown was successful on appeal at the Court of Appeal, then they have the option of appealing to the Supreme Court of Canada, and their lawyer would assist them with that. If they are unsuccessful at the Supreme Court of Canada, they have the option of writing an application to the Minister of Justice for review of their conviction. So this is where Innocence Canada comes in, as we work with our clients on preparing these applications, and I will explain this shortly. So with that said, back to Innocence Canada. Innocence Canada is a national nonprofit organization based in Toronto. The organization was founded in 1993 as the Justice for Guy Paul Morin Committee. This grassroots organization was formed with the intention of overturning the conviction of Guy Paul Morin. Following this case and his exoneration, the group reformed as the Association in Defense of the Wrongly Convicted, or AIDWIC. A few years ago, AIDWIC was rebranded as Innocence Canada. Innocence Canada works on a pro bono model. I can explain this later if you'd like me to. We have many volunteers across the country, including pro bono case review lawyers. We also have a large roster of students who participate in a variety of programs. So our mandate at the organization, most of Innocence Canada's efforts have been the review and correction of wrongful conviction cases. However, over the years, our legal education and advocacy initiatives have become an integral part of our organization, and they continue to grow. We generally have anywhere between 80 and 95 cases in various stages of our case review process at a time. While Innocence Canada recognizes the injustice and tragedy in any wrongful conviction case, we don't have the resources to deal with any but the most serious criminal offenses. For this reason, our focus is only on homicide cases. But we deal with every application on a case-by-case basis. So when warranted, we may review a non-homicide case, but that's fairly rare. So once we believe someone is innocent, there are two legal options to have their conviction overturned. The first option is through the appeal process, which I mentioned a bit before. And the appellate route, however, is not the procedure that Innocence Canada specializes in. Generally, we ask that all of our applicants have exhausted their appeals before we take on their case, although there are some exceptions to this rule. So the second option is ministerial review pursuant to section 696.1 of the Criminal Code. So this is our area of expertise. It's what I focus on a day-to-day basis. And section 696.1 basically allows the Minister of Justice to review a conviction. to review a conviction where there are new matters of significance in the case. That's the language in the section of the criminal code. So the legal test itself under section 696.1 is that the minister must be satisfied that there is a reasonable basis to conclude that a miscarriage of justice likely occurred. Now, there are two main requirements to file a section 696.1 application, and the first is that they must have exhausted their appeals. And that means at minimum, they had to have appealed their conviction to their provincial court of appeal. So the second requirement, which is under section 696.4 of the criminal code, mandates that the minister must consider whether the application is supported by new matters of significance that were not considered by the courts or in a previous ministerial review application. Now, that's a lot of fancy language. Basically, it just means that there must be new and significant evidence in the case. So it's a hard test to meet, and some examples of new and significant evidence include where new witnesses have come forward in the case, or maybe we've contacted new experts who are able to provide us with a new analysis on the evidence. There may be new scientific techniques that have been released since the conviction, like new DNA technology. There may be relevant evidence that was not initially disclosed by the prosecution or the police, which might become important. And there may also be significant evidence that someone else committed the crime. So the reason for this requirement of new matters of significance is because the minister's office is not meant to act as another court. So it's not like another appeal court. It's supposed to be an extraordinary remedy, and it's a very hard remedy to obtain. So we have to do a lot of work in order to get to the point where someone might be exonerated. So a case will typically come to Innocence Canada in one of two ways. The convicted person might submit an application to us directly, or we may get a referral from their lawyer. So after the case meets our initial criteria, it will be placed on the waiting list until we have the resources available to review that case. So we have an extensive case review process, which is overseen by our case management council, our staff lawyers, which I'm one of them, and by our case review committee, which is comprised of senior members of the criminal bar across the country. The first stage of our review process is the preliminary review. And at this stage, Innocence Canada staff lawyers will obtain all necessary information from the applicant's lawyers, the Crown, the court, and any other kind of sources we can get information from. So this might be forensic labs or the archives or whatever. So Innocence Canada staff lawyers then review the case with the case review committee to make a decision about whether we will continue with the case or not. The applicant will then be notified of our decision. So the second stage of the process is the full review. A case will proceed to this stage when we think that it's possible significant new evidence may be found. When a case proceeds to this stage, a case reviewer will be assigned to the review. Now our case reviewers are pro bono criminal lawyers who work across the country with us. And they will be assigned to and will gather necessary information, and they'll recommend and undertake further investigative steps. So maybe they'll recommend that new witnesses be contacted, or a certain forensic test might be done, or whatever they think is necessary in that case. The full review results in a report with a recommendation to continue to the investigative stage or to discontinue and declare the case inactive. So the case reviewer will work with Innocence Canada's staff lawyers to make sure that the plan for reviewing the case and obtaining new evidence moves forward as quick as we can. Innocence Canada's staff lawyers will assist with finding experts, retaining investigators, obtaining disclosure and documents, and any other necessary tasks. The results of the investigative plan will be discussed with the case review committee, and a decision will be made about whether there is sufficient new evidence to file a Section 696.1 application to the Minister of Justice. If there's sufficient evidence, new and significant evidence, then we will officially adopt the case and that person will become our client. So the process of drafting the application itself can take up to a year. I've been a signatory on 2 of those applications so far, soon to be 3. And it takes quite a lot of time. When the application is complete, we will submit it to the Criminal Convictions Review Group in Ottawa, and I'll come back to that in a moment. So as a staff lawyer, it's my job to make sure that our cases are moving through this review process. I will review the file, look for potential legal issues, and brainstorm further avenues of investigation, such as further forensic testing, perhaps hiring a private investigator, and so on. I will also communicate with our case reviewers, and I will communicate with experts and private investigators that have been assigned to work on the case. So if we've decided to write a Section 696.1 application, I will take a deeper dive into the file, and I usually start with going through all of the trial transcripts and evidence at the trial. I'll look through court documents and the police investigation, and I'll look at what has been done to reinvestigate the case over the years. Sometimes we get the case 10 years down the line, and a lot might have been done in that period. I'll also do legal research on the main legal issues in the case, and I'll work on drafting the application itself. Excuse me. So my role differs somewhat than other lawyers working in criminal law, as I'm sure you've gathered by now. I don't go to court on a regular basis like a trial lawyer would. And my job is more like a criminal lawyer specializing in appeal work, because I spend a lot of time reviewing reviewing the investigation in the trial itself, and doing legal research to undermine the foundation of that conviction. Innocence Canada lawyers do, however, work with other pro bono lawyers regularly, and we will go to court if one of our clients is successful in their Section 696.1 application, because we'll help them through that whole process. And I'll explain this a bit more later. So back to the review process. Once Innocence Canada files an application, it goes to the Criminal Conviction Review Group for further investigation. So it's a very long process. The Criminal Conviction Review Group, or the CCRG, is an independent part of the federal government, the Federal Department of Justice specifically, and they're responsible for reviewing the application and advising the Minister of Justice on the appropriate remedy in that case. Innocence Canada's last application that I worked on was over 200 pages long and accompanied by 31 volumes of additional material. So it's quite a lot for them to review and go through themselves. If the application passes their preliminary assessment stage, meaning the CCRG believes there's new and significant information in the case, we can apply to have our client released on bail pending the CCRG's decision in the matter. So this is not a guarantee, but we have been successful in some of these bail applications. In the investigative stage at the CCRG, the lawyer will closely examine new information and see if it's reasonably capable of belief and relevant to the issue of guilt or innocence. This might require interviewing witnesses, conducting forensic tests, consulting with police, prosecutors, defense counsel, and basically doing their own investigation. However, with that being said, often we've done a lot of that preliminary work, so they'll review our work and interview our own experts and investigators, and then take any additional steps they feel are needed in that case. So this process can take quite a long time. One of our applications was in the investigative stage at the CCRG for 5 years. Once their investigation is complete, a report will be written and the applicant will be asked to provide comments. So we'll provide those comments. On the basis of the investigative report, the minister will then make a decision as to whether or not they are satisfied that a miscarriage of justice likely occurred in that case. It is then within the minister's power to either order a new trial, refer the case back to the Court of Appeal, or dismiss the application. So if the case gets sent back to court, this whole process of court process starts over again. And this is when Innocence Canada lawyers typically get involved with the courts. So now that we've taken a very thorough look through the process, I'm going to talk to you briefly about some of the causes of wrongful conviction and some of our exonerees. So I'd like to start by talking about one of our exonerees, William Mullins Johnson. Bill was charged with the first-degree murder of his 4-year-old niece, Valen. At the time of Valen's death, Bill was living with her family. He was alone with her from 7:30 p.m. to 9:30 p.m. on the night of her death. Her mother returned home at 9:30 p.m. and her father came home at 2 a.m. Valen was found dead in her bed at 7 a.m. So the Crown's theory was that Bill killed his niece while sexually assaulting her. A team of physicians, including the now disgraced Dr. Charles Smith, concluded that Valen had been strangled to death between 8 p.m. and 10 p.m., meaning that Bill, who was alone with the child at the time, had to have killed her. They also found that she had been subjected to chronic sexual abuse. One of the doctors, who was not a pathologist, and that's an important point, said that it was one of the worst cases of child sexual abuse that she had seen. Despite there being no forensic evidence to connecting Bill to Valen, he was convicted in 1993 and sentenced to life in prison without eligibility for parole for 25 years. In 2007, the Minister of Justice directed a reference to the Court of Appeal. The court admitted fresh evidence, which made it clear that Bill was convicted on the basis of flawed pathological evidence, and that there was in fact no evidence that Valen had been murdered or sexually assaulted. While the cause of death could not be determined absolutely, 2 forensic pathologists who reviewed the case concluded that she likely died of natural causes. An acquittal was then entered by the Ontario Court of Appeal. So everyone in Bill's family over this period of time thought he'd sexually assaulted and murdered his niece. No one thought that the doctor just got it wrong. And in the end, no actual crime was committed in this case, and Bill spent 12 years in prison for a crime he did not commit. So Bill's case shows us why it's so important that we understand how wrongful convictions happen. On this slide, you will see the main identified causes of wrongful conviction, but it's important to note that rarely do we see only one of these factors operating in a particular case. We'll often see a combination of these, or a perfect storm of reasons that put an innocent person in prison. So we'll explore, in the interest of time, only one of these causes today, and that's tunnel vision. So, tunnel vision is a natural human tendency which can lead individuals working in the criminal justice system to focus only on one suspect at the exclusion of all others. In effect, they select and filter evidence on the basis that the suspect must be guilty, while ignoring and suppressing evidence that points away from that suspect's guilt. Ultimately, it can influence how we interpret the information that we are getting. So it skews with our thinking in the case. That being said, it's important to remember that tunnel vision is more often a result of institutional pressure or a strongly held belief that that individual is doing the right thing, as opposed to the police officer or the Crown or the forensic scientist actually being malicious or indifferent. Tunnel vision can also result from or impact other causes of wrongful conviction. For example, mistaken eyewitness identification could lead to police tunnel vision, with them focusing all the attention on one suspect who was improperly identified in the first place, instead of looking for other leads. Another example is forensic evidence, which can lead to the police being convinced of the suspect's guilt, and that results in tunnel vision setting in. Tunnel vision can also lead to improper conduct by officers in the case if they are convinced of the suspect's guilt. This is called noble cause corruption. For instance, they might put improper pressure on a suspect in order to obtain a false confession through coercion. Tunnel vision can ultimately affect everyone working in or associated with the criminal justice system, including police, prosecutors, forensic scientists, and even the media. So one devastating example of tunnel vision is the case of Glenn Assoon. And Glenn is Innocence Canada's most recent exoneree. If you're interested in learning more about his case, you can actually listen to season 7 of CBC's podcast Uncover, which focuses exclusively on his case. Glenn Assoon was recently acquitted after 17 years in prison and 4 years on bail. He was convicted of the 1995 murder of Brenda Way. Brenda was a prostitute in Dartmouth, Nova Scotia, who years earlier was in a 2-year relationship with Glenn. So the original detectives on this case concluded that Glenn was not a viable suspect, and they turned their attention elsewhere. However, in the summer of 1996, 2 new investigators were assigned to the file and began attempting to collect evidence against Glenn. They eventually came up with 5 witnesses whose evidence constituted the entire Crown case against Glenn at his subsequent trial. So there was no forensic evidence. Margaret Hartrick was also a Dartmouth prostitute, and she reported to the police that she saw and talked to Glenn the morning before the murder and near the location where the murder occurred. Much later, Glenn's nephew, a cocaine addict, reported to the police that Glenn had confessed to him to committing the murder during a phone call. Glenn was arrested in British Columbia on April 5th, 1998, and he returned to Nova Scotia for his trial. During his stay, a jailhouse informant claimed that Glenn confessed to cutting his ex-girlfriend's throat. Not much later, On September 17th, 1998, a teenage prostitute told the police that she had in fact had an encounter with the murderer who abducted her, sexually assaulted her, and told her that he had killed Pitbull, which was Brenda Way's nickname. So when she saw the mugshot of Glenn on TV, after which he had already been arrested for Brenda Way's murder, she believed that Glenn must be her attacker, and that the person who confessed to her to killing Brenda Way. So she then went to the police, and she was the Crown's key witness. At his trial, Glenn was denied legal aid and was unable to obtain a lawyer. He then had to represent himself without any knowledge of the law and with limited education himself. Although there was no physical evidence that could be traced back to Glenn, he had an alibi which was confirmed by a friend, and he was convicted ultimately of the second-degree murder of Brenda Way and sentenced to life in prison without eligibility for parole for 18.5 years. So later, the Crown's key witness had doubts and wasn't sure anymore if Glenn had actually committed the crime. She thought that maybe she had misidentified him. Despite her misgivings, she didn't mention her concerns or doubts to the police. In actuality, Glenn was living in British Columbia at the time that this witness was attacked in Nova Scotia, and he could not have attacked her. So in 2004, Jerome Kennedy was assigned to work on Glenn's appeal. He asked for disclosure of documents from the RCMP between 2004 and 2006, and he only received incomplete and misleading answers from them. It was later found that the documents in possession of the RCMP were destroyed. So those files could have actually helped Jerome Kennedy win the appeal. Kennedy put forward the theory that there were other potential suspects in this case, and if he had had those documents, he would have been able to present this as an argument at the Court of Appeal. So the truth was that around 2002-2003, a criminal profiling specialist in the VI-class unit, Constable Dave Moore, had actually concluded that a man named Michael McGray was the more likely suspect in Brenda Way's murder. At this point, when he made this determination, Glenn had been in custody for over 4 years. Michael McGray had been convicted of several murders. The murders that McGray were convicted for were similar in nature to the murder of Brenda Way. McGray was a Canadian serial killer who was found guilty and imprisoned for the murder of 7 people. In a letter, McGray confessed to killing more than 7 people. So as the years passed, Innocence Canada got a hold of the case and decided to try and prove Glenn's innocence. They started an investigation, and lawyers Sean McDonald and Phil Campbell took on the case. Innocence Canada obtained evidence from 2 individuals who claimed that McGray confessed to killing Brenda Way. In 2013, Innocence Canada submitted a Section 696.1 application to the Minister of Justice. And in early 2019, Justice Minister David Lametti quashed Glenn's conviction and ordered a new trial. On March 1st, 2019, Glenn was finally exonerated. If the police hadn't focused on Glenn Assoon to the exclusion of all other potential suspects and ignored evidence that Glenn couldn't have committed this crime, it is possible this wrongful conviction would never have occurred in the first place. So the reality of wrongful convictions is that the justice system makes mistakes, and it's the role of every lawyer and every person working in the criminal justice system to be vigilant and educated on the causes of wrongful convictions and to ensure that they are prevented and that the right person is brought to justice. In some cases, especially those that Innocence Canada works on, these mistakes can cost everything a person has. While we're focused on getting the truth out there, the reality is that the wrongful conviction haunts our exonerees throughout the rest of their lives. You can never truly be free from it, and it's very tragic circumstance, not only for the person and their family, but also for the victim's family, because the true perpetrator of the crime is never brought to justice and could go on to commit more crimes in the future. So thank you for listening, and I'll now stop my presentation, and I'd be happy to answer any questions that you might have. I'll just stop that. So I see we have, no, we don't have any questions in the chat. So you're welcome to ask me any if you want to take your mic off, or your mic off, unmute, whatever the term is. Oh, okay, so Sana, do you have a question?
Hi, yeah, my name is Sana. Thank you for the presentation. It was very insightful. And there were some facts that I really didn't realize how, deep or how, I guess, impactful some of the misconducts can lead to. It was, yeah. My question kind of goes to how Innocence Canada might ensure that the people who are kind of working with them and the lawyers that are involved, how do they ensure that these lawyers are people that are unbiased, are people that will, truly want to find what's best for their clients?
Yeah, that's a great question. So we often only hire lawyers who have been recommended to us by other lawyers who already work for us. So we really go on a word of mouth kind of, I wouldn't say hiring policy, because they work for us pro bono, which means they work for us for free, except for the staff lawyers like myself. So we definitely try them out for a while and see if the fit is right and if they've done enough work on the file. If not, then we'll reassign it to another lawyer. So really our case reviewers, they're usually involved in the front end stages of the case review process. And at some point, if we decide to adopt the case, then that's when our staff lawyers and members of our case review committee themselves, which are composed of senior defense counsel across the country who have worked with us for ages, then we'll take over the file. So yeah, it's a great question. It's really trial and error and seeing if that lawyer is a good fit for us. Yeah. Yeah, Sana?
May I ask a second question as well?
Yeah, of course.
What inspired you to take on such a position? Because with criminal law, I mean, it's like, even in the presentation we just went through, there's so much trauma, I would say, not only for yourself, but for the people who you're dealing with. Yeah. And I know that, like, it must be so mentally straining to go through cases like that on a daily basis, and to know that, essentially someone's life is now dependent on whether or not you're able to prove that they are innocent. Even if what you believe is true, it takes a lot more effort, like you walked us through, the amount of evidence that you need and the amount of years that go into trying to. So how do you maintain that just mental strength to be able to continue with something like that?
It's not easy, and actually you'll find in criminal law there's a lot of burnout. People who start in the profession often switch professions after 10 years because it is really mentally exhausting, and it's also, it never ends, especially as a defense lawyer, because you're often getting calls in the middle of the night to represent a new client. Often people are arrested in the middle of the night. It's the reality of it. So yeah, there's definitely a lot of burnout. I think the people that stick with it are really good at compartmentalizing and can really put that aside. And I think it's important as a criminal lawyer to be able to feel compassion and empathy for your clients. I think that's really important, but it's also important not to let it affect your own life. So having really good coping strategies. Being able to talk to your colleagues is really important as well, to kind of put it all in perspective. So yeah, I'm not gonna lie, it's not easy by any means. You definitely have to take a deep look into yourself to see if that's the kind of thing you can manage. And you know, like, you have opportunities to do that. If you're an articling student, then it's a 10-month period, and if you think you can't do it, then you can always switch out, right? So yeah, it's not easy, but yeah, you definitely have to be good at compartmentalizing and have a bit of hope that change can happen as well. That's what part of our goals are with the organization, is to hopefully prevent some of these wrongful convictions before they even happen by advocacy and education. So that's important as well. Hope that answers your question.
Okay, thank you, Rebecca, for that. Thank you for the informative presentation. I hope everyone enjoyed it, and we will soon be moved back to the main hall.